July to 1st July. 2nd July. On 2nd July. Interim order to continue. देखिए the interim order that you call. Yes.
Supplementary list item number 1 for judgment.
Judgment. Oh. Thus, from a conspectus of the analysis made herein before, this court holds that the claim of parity raised by the petitioners with their counterparts of UCE Burla is justified. Consequently, the impugned order passed by the Secretary under Annexure 4 is held to be unsustainable in the eye of law. Having held thus, this court would make it clear that the petitioners would be entitled to the pay scale of the senior scale, that is senior teaching assistant, from the date of completion of 5 years service as teaching assistant. Such benefits shall be granted till the date they were promoted to a higher scale and or granted financial upgradation in the form of TBA, ACP, RSCP and MSCP as the case may be. The financial benefits be calculated and revised and disbursed to the petitioners accordingly. In the result, the writ application is allowed in terms of the directions and observations made in paragraph 16. The opposite party authorities are directed to pass necessary orders to give effect to the direction of this court within 4 months from the date of production of certified copy of this judgment by the petitioners.
Item number 2 for judgment.
Thus, from a conspectus of analysis of facts and law as well as the developmental facts, this court holds that the application for review is firstly not maintainable, and even otherwise no valid ground has been cited to persuade this court to review its order dated 23/2/2023, passed in WPC number 5316 of 2023. Resultantly, the review application is dismissed.
Item number 3.
This case,
Relative quality.
this case
Yes.
was adjourned. Only the issue to decide whether
Oh, yes, yes.
person
That part. Yes.
who is not made a party in the appeal or suit can file an appeal, madam.
Yes.
And I will show to your lordship that is reported in 1973 SCC.
Yes.
Your lordship will kindly see.
No. Here the
I have
question is.
indicated.
Here the question is. I am convinced that you have a right, provided the notice has to go. That is
Nah, nah.
no.
It is-
I will issue notice.
Madam,
No. I will issue notice.
Madam, it is between the court and the applicant, madam.
No.
Your lordship.
This also you are forgetting order 22 rule 5, where there is a question of who will be the LR, who will be the substituted party. Then the court may also direct an inquiry to be caused. Inquiry.
Yes, madam.
So here what has happened is, so according to you, some of the legal errors have been substituted and some have been left out. You have a case. You certainly have a case. Whether you are a person aggrieved or not, we do not know. This court doesn't know. You are claiming it. So let notice go. Why are you worried? Let notice go. Notice ଯାଇକି ଆସୁ ଆପଣ ହବ କଣ
ଖାଲି ସେ proposition of law ଟା ଖାଲି ଦେଖିବେ।
ହଁ କହୁନାହାନ୍ତି ଆରେ ମୁଁ କଣ ମନା କରୁଛି ଆପଣଙ୍କୁ ମୁଁ କହିଲି ଆପଣ ଡିସିସନ ନେଇକି ଆସନ୍ତୁ ଆପଣ ଆଣିଲେ ମୁଁ କଣ ମନା କରିବି ଆପଣଙ୍କୁ ଦେଖିବା ପାଇଁ if you want to argue you can argue the whole day
ନାଇଁ ମୁଁ ଆଇ କରିବି ଆଜି ଲାଷ୍ଟ ଡେ ଟା
ନାଇଁ କରିପାରିବେ ମନା
ନାଇଁ କରିବି ନାଇଁ
what I mean to say is that you have got full opportunity to argue. I will not stop you from arguing.
Paragraph 3
It is well settled that a person who is not a party to the suit may prefer an appeal with the leave of the appellate court, and such leave should be granted if he would be prejudicially affected by the judgment. Yes, that is what I am exactly. That is what I am saying. I am not saying that you don't have a right, but notice has to be issued before allowing this application.
And leave of the court.
I will grant leave. I will grant leave, but only after hearing the other side.
Leave of the court will be granted. Only examining whether he or she is affected by the judgment.
Without hearing the other LRs, can the court decide? Ms. Mahapatra, please consider. I am not rejecting your application. I am simply issuing a notice to the state as well as the other LRs who have already been implemented. That is only. No, state को हबो state party करिथिले और state को हबो ना
state को हबो
state काहे की party कोलेनी they must answer
हां सेही गोटे ग्राउंड रे भी आगे सेटा सेट हे जाय
सेटा आपण CMP फाइल कोलेनी CMP file kolen. You should have filed a CMP. Yes.
No, after judgment,
no. At that stage, at that stage, you should have filed a CMP.
Again.
Challenging under order 22.
Again.
So ना हमें कहीं कि इतने order पढ़ियो हम notice take कर दो तापर notice से पाई कि sufficient लेके असले allow कर दो सब in the Mr. Vivekananda Bhuya is probably appearing for the other LRs.
Again.
So I don't think he will object.
I
mean notice कर दो he may accept he may not accept. This is a civil matter you don't know. If he accepts notice कौन मना करेगी? Issue notice to the where is the IA? Yes. Better hover. Issue notice to opposite all the opposite parties. issue notice to the opposite party.
ଖାଲି
ଅନ୍ୟ ମାନଙ୍କୁ କୋଉମାନେ ଏଲଆର ଯୋଉମାନେ ନୁହନ୍ତି ଏଲଆର ଯୋଉମାନେ ଖାଲି କୁହନ୍ତୁ
ଏଲଆର ମାନଙ୍କୁ ଦେଇଛି
ସେମାନେ କୁହନ୍ତୁ ଅପୋଜିଟ ପାର୍ଟି 1 and 2 କରିଦବା
ପ୍ରୋଫର୍ମା ରେସ୍ପୋଣ୍ଡେଣ୍ଟ ଖାଲି ସେଇମାନଙ୍କୁ କହୁଛି
ଆଉ କୋଉନାହାନ୍ତି
in appeal number 524 my lord 3940
3940 ତ
ଆଜ୍ଞା
all right it is submitted by Ms. Dipali Mahapatra, learned counsel for the appellates petitioners that the present petitioners are the legal heirs of कौन था ना
late Prabodh Rai
late Prabodh Rai
ଆଜ୍ଞା
who was defendant number
who was plaintiff my lord
who was the plaintiff
number 5 my lord
was plaintiff number 5 in the suit before the court below
ଆଜ୍ଞା
stop
plaintiff number 7 my lord
plaintiff number 7 he having expired the state filed an application to substitute his legal heirs
he was died during pendency of the appeal my lord
he died during pendency of the first appeal preferred by the state. The state filed application for substitution, but including only
son
the wife and son present opposite party numbers 39 and 40 as the substituted respondents. It is the case of the present petitioners that they are the daughters of the deceased respondent and have a right to sue. And therefore, they ought to have been substituted. Stop. Issue notice to opposite party number 1 and 2 and 39 and 40 by registered post with AB. Returnable within 4 weeks. Requisites be filed within 3 working days, or what can I say? 3 working days you will file, or 3 working days. Less this matter. Put a short date kar.
Commission 22nd July.
ଆମର 4 weeks ये जून रे सर जीवो तो फर्स्ट वीक ऑफ जुलाई रे करन
First July.
ऑन 1st जुलाई
ଆଜ୍ଞା
इतरे लिखिबे नोट फॉर द टाइमिंग रे एथिक थाउ था नोटिस दरकार
second time
same order it will be better, you will get a clear order.
ତେବେ ଆଜ୍ଞା related ହେଇଛି ପୁଣି 2039 ମାନେ settled position of law a person who has not made a party
No, probably I think probably they were not aware of the appeal. The daughters are they married daughters? They probably जान नथिबे कि कोन हितो कि probably not advised.
फाइट रे मु कोसार रहई ना
हाँ नहीं you have a right co-personal right you have got a you are the co-personer इतरे कुछ संदेह नहीं but ସେମାନେ ଜାଣି ନथिबे सेति में बोधे चैलेंज करे ना
आज्ञा ते जियो माने जानना
सेम को
आगे।
ସେମାନେ बोधे
नॉलेज सीएमपी तो फाइल
they should have CMP file कर देथिले जाइता yes
Item number 5.
item 5
Item 5
Hmm.
is a transfer petition preferred by the wife
Hmm.
for transfer of CP filed under section 13 by the husband before
କୋଉ ଜାଗା
Noyagarh to both.
ନୟାଗଡ଼
On the ground that I have filed a guardian petition before the learned family judge both.
guardian petition
So also I have also another petition I have also filed a TV proceeding. So 2 proceedings are pending before the both. Second aspect is that my lord I have also filed a FIR against my in-laws in Daspola. So there is also apparent threat to my life. And
already issue notice to the opposite party by speed post requisites for which shall be filed on the next working day of the office
Can
working day of the office I don't know you find out next working day of the office list this matter on
9th July.
9 July
there is an IA, my lord.
in the meantime if any application for adjournment is moved just take it further proceedings in CP number 137 of 2023 pending in the court of learned judge family court Noyagarh shall remain stayed till the next date.
Much obliged.
Item number 6.
My lord, wife's application seeking transfer of the CP from Jajpur to Sambalpur. Sambalpur, she has filed 2 cases, DV and as well as 125. My lord, and your lordship will see page 10.
Take notice, Mr. Bose.
Yes,
Issue notice to the same order. Jai ji, order karo. जो खाली लिखो Date भी same रखो, हाँ? Further proceedings and so shall remain stay till the next date.
Great.
Item number 7, the satisfactory bail.
May I please, Lordship? Lordship, last occasion, may Lordship will call for city, madam.
Serious ଥିଲା? Case matter କଣ CD ମୁଁ? The matter of breach of agreement, therefore civil further submit the offence is not paid out as petition was in more than 6 months to the High Extra equals the court to refer the case to mediation. Whether there are prima facie materials to show commission of the offence under section 307.
No, madam.
No.
307 is not there. So far as examination of independent witness are concerned, there is no allegation of assault, madam. Only this is a contractual dispute. The petitioner has taken a hydraulic, one Volvo hydraulic excavator on lease basis with a monthly rental. Thereafter,
Somebody was appearing for the other side. DK Sahu, Mr. DK Sahu was appearing. He had made a submission that the petitioner owes him more than rupees 60,000. Today, if we grant him bail, you will get a premium now. Wait, pass over.
Madam,
Pass over.
Item number 8,
so
Again.
before launch, madam.
Before launch, after launch, ମୁଁ ଆଜ୍ଞା exactly ପାଞ୍ଚ ଦେଖି କହିପାରିବିନି ତଥାପି
Brave for
pass over ପରା it court is passing it over to allow the other side to appear. Last time he was there. Item 8. Chalo, pass over.
item number 9,
Please, your lordship.
Item 9.
Main please, your lordship.
Yes.
I am in the virtual. Lordship, this is the case of way back of 2014. Lordship, in this
order, madam. As of 1202 by 24.
So that blocking of the road.
Yes, madam.
Same order.
same lordship,
item number 10,
deeply obliged.
Yes.
Offense under 307 is there, my lord. This person have not named the FIR. And my lord found that the earlier bail application,
The person who has been named, your
they
lordship.
have religion bail and holding that there is a simple interest that is instructed implemented by the law.
All right, same order.
But they have not been named, others. Yes.
item number 11,
379 of IPC regarding theft of a max pickup vehicle, my lord. In the meantime,
Theft of a
max pickup
Max
vehicle.
max pickup vehicle.
Right.
Vehicle was recovered.
It was
Somebody has been granted bail.
yes, my coacus person, your lordship.
All right, same order.
Yes.
One thing, charges from the 379 and 34 of IPC.
34 will not be a graver offence.
30% add no kale.
Oh, add, ଆପଣଙ୍କ ଇଏରେ add କରିବେ।
My-
2024 ତ add କରିପାରିବେନି। କଣ କରିବେ? ଆଚ୍ଛା, learned counsel for the petition is permitted to correct the ନା ଆମେ ଲେଖିଦେବା ଏଠି। It is submitted that କରିଦେବେ କଣ? The petitioner is the petitioner is apprehending arrest in connection with such and such case instituted for commission on for the alleged commission of offence under
379.
379 34 IPC.
Okay.
बाकी जा रहा है।
item number 12,
May I please, Lord? My lord, dispute with police in drunken condition, madam.
What?
Earlier filed, withdrawn.
I told.
पुलिस उनको बड़े ले मत भी
Co-accused has been granted.
नहीं नहीं लिखे रिकॉर्ड कर दो।
No, my lord, it was by on a trial.
What is the allegation?
My lord, while they are consuming liquor, the police party reached at the spot and there was a hot water exchange between them. In public, they are consuming liquor.
ସେଇ ଥାନାରେ ସେ ଆପିୟର କରିବେ ସେଇ ଥାନାରେ ସବୁଦିନ ଆପିୟର କରେଇଦବା ହେଲା ନିଶା ଛାଡିଯିବ ଏକାଥରକ ନା କଣ ଡକ୍ଟର ପଲ୍ what do you say condition on the condition that they will appear before the same police station every day
Yes, madam.
the petitioner is apprehending arrest in connection with such and such case. It is alleged that the prosecution case is that some persons were consuming alcohol in public place. Stop. When police reached the spot and asked them to refrain from doing so, they started abusing the police personnel in obscene language and also pelted stones at them. Stop. One of the co-accused persons, namely Pakka alias Prakash Behra, has been released on bail as per order passed by the court below. The petitioner stands on the same footing. Such view of the matter. No, Mr. Julian, stop. Considering the nature of accusations and the materials on record, surrender, release on bail. Condition court, he shall appear before the IIC of Airfield Police Station, Bhubaneswar, on every alternate day for a period of 1 month, and such fact shall be certified. Each day appearance before the court.
Item 13.
Please, Madam. Now, this is the second bail application, my lord. Earlier, your lordship was granted liberty to the petitioners to surrender before the court below, and the court below will allow the grant bail if the injuries sustained are to be found simple in nature. But, my lord, that injuries were found to be grievous, and subsequently, my lord, one petitioner prior to, in ABL appeal number 14037 of 2023, which your lordship passed, surrendered before the court below, and subsequently he has been released on bail by this honorable court, my lord. That I have annexed it.
So you should have sought for modification of this order.
My lord, no, injuries are grievous in nature, my lord.
So you, whatever, you seek modification of that order instead of filing a new fresh application, which is not maintainable. It is not maintainable. Who advised you to file a fresh application when already you have got an order?
Yes.
Already you have got an order.
That your lordship may kindly see page 20.
I cannot touch that order now. Had you filed an application for modification, I would have deleted that portion, or I would have asked the court below to maintain parity.
But that observation.
How can I observe that? How can I observe that in a fresh application? You should have filed a petition for modification.
I'll do that.
That will come after vacation. Or you try during vacation by filing application, necessary application for modification, permitted to withdraw. With liberty to file application for, with liberty to file appropriate application in the disposed of bail application. Yes.
Item 14.
Offense under section 341, 294, 323, 307, 320, 332, 353, 379, 506, and 34 of IPC Malon. Earlier, Malon, this
You were not named in the FIR.
No.
Now,
10 to 12 unknown persons. But
during the course of investigation, the local people, Malon, a statement of the local people, the petition.
whose statement? Read one statement.
Page 5, Malon.
Yes.
Page 5, Malon, during the course of investigation, the alleged.
Page 9.
Page 5, Malon.
Page 5.
Statement of my person, Malon.
I don't get it. Who has said?
Village people of the.
No, ki tanga na kono? Podu na thi? Statement of 161 statement achi.
no.
Nahi to okay.
Government village.
No. Earlier you had approached this court. This court did not find that you are connected in the, you are nowhere implicated in that case. So anticipatory bail application is not maintainable. If you think that somebody has stated your name, then bring the 161 statement.
Other bail orders he has annexed, but their case diary has come and on instructions they have been released.
So how will it be maintainable? Earlier application, no, co-accused, you don't understand, sir. Co-accused has been named in the FIR or named by some person examined by the IU. In your case, earlier also you had come, your name was not there in the FIR. That is why the anticipatory bail application was not entertained.
Statement of the village.
Village kahar ho gaya? Kohu nathi gote kahidel sinte hoge village bole kahidel gote statement dekho nathi. Anantu se statement anantu dekhiba. Release this matter after vacation. Date kar diyo. In the week commencing We commencing the Karna. Huh.
8th July.
8th July. Yes.
Item 15.
So offense Miller, 341, 294, 323, 354, 379, 506, 353 and 3405. Allegation I am placing Miller, page 10 of the that is FIR Miller. The whole allegation against the petitioner was he was selling the country liquor and he was apprehended. And while the seizure list was getting prepared, he make a hola bola for all.
Somebody has been granted bail.
Somebody has been granted bail.
Siddheshwar Samanta Singh.
Yes,
That is Siddheshwar Samant, but his name is not in the FIR.
But here your lordship would find that I have obtained the entire certified copy of the order. He has never been forwarded. No, whatever the seizure list was available on the record, there was no seizure list with regard to the liquor.
No. Are you implicated in this offense?
Yes.
Where your name doesn't find place in the FIR?
Yes, Miller. My name finds place in the FIR.
Let us see. Let us see. What is your name?
I'm placing the FIR, Miller.
Hmm.
I, Srimati Sita Pradhan 40, Basudev Barik, Atrapada, so and so. As per direction of IIC today, dated so and so evening, I along with ASI SK Beura and HGA 162 R Khotwan along with PS vehicle number so and so are conducted excise raid at Harapur village and apprehended one Undu Bishwanath Singh, who was selling country-made ID liquor to the general public. At 8:30 p.m., ASI SK Beura seized 10 liters of ID liquor from the possession of Undu Bishwanath Singh. And while preparing the seizure list, accused Gundu Bishwanath Singh made hola, and all of a sudden, Bapi, Vijay, and all other coercive patrons, they.
Is your name there here?
Yes.
What is your name?
Gundu, other persons are not there. I only made hola bula, and the country
That
liquor
is-
was seized from the possession.
What is your name? What is your name?
My name is Gundu Bishwanath Singh Miller.
Acha, Gundu Bishan.
Biswajit Singh.
The lordship,
He is filed against my person is Biswajit Singh.
ସେ ଗୋଟେ ଲୋକ ଅଛି।
କୋଉଠି ଆପଣ ଲେଖିଛନ୍ତି? ବିଶ୍ୱଜିତ ସିଂ alias ବିଶ୍ୱନାଥ ସିଂ alias ଗୁଡୁ।
Yes. The lordship may see
All right.
something the all the
नहीं दरकार नहीं। ये सेम ऑर्डर।
That is 1407.
Same amount of same order, same condition.
your lordship. Okay.
Item 16.
My lord, item number 8 I have left from the board, my lord.
No, please. That is the second judgment of the petitioner, my lord. Now, 20B, 2C, 25, 27, and 29, 25 happened. And my lord, in this case, my lord, 3 accused persons already.
What is your name?
My lord. Ashutosh Mistry.
Ashutosh Mistry.
His name is not in the FIR.
FIR ନା ନାହିଁ ଇଏ ହଉଛନ୍ତି ଗାଡିର ଓନର ମାଲ 3 ଜଣ ମାଲ ଅଲରେଡି ଗଲେଣି।
I had rejected it.
ନାହିଁ so 3 ଜଣ ମାଲ ଗଲେଣି।
So what? Rejected it. So my order will go. I have rejected it. I have said that it shall be open to you to renew your prayer before the court below, which shall be considered on its own merit on the same day. Now again you come to this court. How will it be maintainable? Tell me.
Parity ମାଲ
What parity?
3 ଜଣ ବି ଗଲେଣି।
Yes, what you said?
No, once order has been passed that to surrender and move bail before the court below.
You have not, you should abide by this order. You have not obeyed the order of this court. This court directed you that you can renew your prayer before the court below. In the court below, you can raise the principle of parity that others have been released. The court can consider your application, the court below, but not this court. I have specifically passed an order.
parity ମାଲ
Parity ଆପଣ ସେଥିରେ ଗୋଟେ modification ପାଇଁ file କରିଥିଲେ କଣ ହେଇଥାନ୍ତା ନା? Fresh application file କଲେ କେମିତି how will I consider? You should have filed an application for modification in that very application. File after vacation or during vacation. Withdraw it and file. ହେଲା? Permitted to withdraw with liberty to file appropriate application in the disposed of case. ଏଥିରେ କଣ ରହିଯାଇଛି ଡାକିଦିଅ।
So item number 7.
Yes.
So item number 8.
May please, Lord.
My lord, without wasting your lordship's time, I request my lord to kindly have a glance to page number 8, running page number 8. FIR. In the middle portion, my lord. Accused persons were carrying, Manoj Kumar, Niroj Kumar, they were carrying the contraband articles of.
Have you obtained the case diary?
My lord, case diary has not come. But
Yes,
FIR reveals that
They are the
thorough
supplier.
interrogation, finally, they both admitted that they have collected the contraband article from one Pinku Lima
And
and
Ranjan,
Ranjan.
the present petitioner.
Case diary has not come. I have sought for it.
So he is the supplier.
My lord, he is the supplier on the
Page
basis
8.
of his statement.
Ranjan Bira. I think the name sounds familiar. Was he involved in any other case?
No, my lord. My lord. First offender.
He's from Rajapati district.
My lord.
All right. The petitioner is apprehending arrest in connection with such and such case. It is alleged that a truck was carrying contraband ganja illegally and was detained by police. The driver and a helper being apprehended were interrogated. In course of their in course of interrogation, while in police custody, they gave out the name of the present petitioner and another person. There is no other material to show the presence of the petitioner at the spot or of possessing the contraband. Save and except the statement of the co-accused persons, there is no other evidence against him. In such view of the matter, the ratio of Tufan Singh versus so squarely applies to the facts of the case. However, having regard to the nature of accusations and the materials on record, while not being inclined to grant anticipatory bail, surrender release on bail. Kardiyo, appear before the IIC of Mohana Police Station on every Sunday at 10 a.m. for a period of 6 months. Each day appearance before the court, no representation through counsel shall be allowed under any circumstances. Yes.
Item number 17.
My lord, offense under section 21C of NDPS Act, my lord, and the present petitioner is my lord, arrested 3/11 of 2021, my lord.
Yes, yes.
Arrested, my lord, 3/11 of 2021.
The
my
regular
lord.
bail.
Yes, my lord.
3/11/2021. Yes.
My lord, brown sugar is my lord 273 grams, my lord, and prosecution allegation that my lord, two persons standing at Puri near bypass road for selling brown sugar, my lord. Nothing has been seized from the present petition, my lord. Brown sugar was seized, my lord, one dicky of Hero Glamour
You have
motorcycle.
the case diary?
No, my. Or from the bike in which the present petitioners were there, where in that bike, from that bike 273 gram brown sugar was seized. And independent witnesses were examined, they were torn hosted, but the official witnesses are not yet examined.
After the case
My lord, I
diary,
have already filed the deposition copy, my lord.
you filed?
Yes, my lord.
Deposition
Out
copy
of
of that,
7 interested witnesses, 4 witnesses have been examined, my lord.
What is the allegation against him? He was standing,
With a motorbike,
he was going on a motorcycle.
my lord. From that bike,
The brown sugar was in the dicky.
my lord.
Yes, my lord.
Atale kung kuru.
No criminal antecedent, my lord.
No, criminal artist, no. Brown sugar or how many?
Interim.
Interim bail I can consider.
My lord, another co-accused also granted interim bail for a period of 4 weeks on ground that his mother was ill, my lord.
The petitioner is in custody since
3/11 of 2021.
3/11/2021. in connection with such and such case, it is alleged that the petitioner, that two persons, including the petitioner, were going on a motorcycle, which was stopped by the police. On search, 273 grams of contraband brown sugar was found from its dicky. So, it is submitted that the trial has already the independent witnesses examined during the trial have not supported the prosecution case. It is further submitted that even otherwise, trial being delayed, the petitioner is facing serious inconvenience because of certain family problems. He therefore, he may therefore be released on at least anticipatory bail. On interim bail. Learned State Council submits that the official witnesses remain to be examined. Considering the submissions as above and the materials on the court, while not being inclined to grant regular bail, the DL appellate is disposed of, directing the court below to release the petitioner on interim bail for a period of 4 weeks.
Item 18.
May please. Here in this case, my lord, charge sheet has been submitted under section 395 of IPC. Allegation that 4 accused persons came and they took away bike of the informant. In this case, my lord, bike has been recovered from the co-accused Jitu Swine. He has been granted bail. And 2 other accused persons also granted bail by this one.
Anil Kumar Behera. He stands on the same footing. Same order. Same order.
Item number 19.
Please, your lordship. Lords, earlier your lordship was pleased to reject bail of this petitioner. That is in BLAPL 3073 of 2022 on 23rd September 2022. In the meanwhile, my lords, the case has been committed to the Court of Session.
But Mr. Pandit, that was of one Golekha Sethi. That 307.
Golokha is the father and 2 sons.
And others, yes.
Your lordship granted bail to the younger son, rejected the bail of Golokha and this petition.
Yes.
And so far as this petitioner is concerned, my lords, bail was rejected relying on a statement of witness Gajendra Sethi, my lords. Lords, my respectful submission is that in the meanwhile, the case has been committed and the postmortem report indicates, my lords, that the deceased death occurred on 13/12/2021, my lords, in course of treatment, while he was undergoing treatment after 25 days of the occurrence. So it will not be a case under 300. At best, it will be a case under 304 Part 1.
But that Gajendra Sethi has not been examined so far.
No, Gajendra has not been examined. My submission is that even if Gajendra Sethi's evidence is believed, my lords, in view of the fact that the death of the deceased happened 25 days thereafter, and the allegation of assault against this petitioner is that he has assaulted on the leg.
No, but if
Golokha is alleged to have assaulted on the head.
No, if the prosecution is able to show a proximal nexus between the death and the occurrence.
Cause of death is because of the head injuries, my lords.
That's all right.
That is the opinion of the doctor.
I am asking you academically only because the death took place.
My submission is, my lords, that the prosecution cannot show a proximal cause, even if on the basis of statement of Gajendra.
No. I'm not asking about this case. In general, I'm asking you. The death may have occurred some days after the occurrence. But if there is a proximal nexus, if it can be shown, then why will it not be murder? Why will it not be murder?
My submission is, my lord, such a proximal nexus is not available in this case.
No, not in this case, I'm not saying, I'm repeatedly saying, I'm just academically asking you.
Academically, it may be possible.
Yes, that is what I'm saying. Here, maybe as you say, Gajendra Sethi ro padile.
My lord, CD night first time.
Gajendra Sethi
Gajendra statement mu paduchi.
My lord, earlier that bill 12695 or 22. Petitioner has filed.
Their statement hela.
1265.
12695.
What happened in that case?
That your lordship rejected because of the fact that prayer had been earlier rejected.
সেটা বার করো সেই অর্ডারটা 12695 সে দিয়েছেন যে সে তার অর্ডারটা বার নেই What did Gajendra say?
Gajendra stated ମୁଁ ଘରେ ଶୋଇଥିଲି ମା ମତେ ଡାକିଲା କହିଲା ତୋ ବାପାକୁ ଗୋଲକ ସେଠୀ ଓ ତାର ଦୁଇ ପୁଅ ପ୍ରଦୀପ ଓ ପ୍ରଭାତ ହାଣି ପକଉଛନ୍ତି ମୁଁ ଡିଆଁ ମାରି ଗଲି ପୁଣି ବାପ ପୁଅ ମାକୁ ଗୋଲକ ଟାଙ୍ଗିଆରେ ବେକରେ ଚୋଟ ମାରିଲା ମୋ ବାପା ଗୋଡକୁ ପ୍ରଦୀପ ସେଠୀ ଗୋଟିଏ ଧାରୁଆ ଅସ୍ତ୍ରରେ ହାଣିଦେଲା ମୁଁ ଯାଇ ଛଡାଇବାରେ ସାନ ପୁଅ ପ୍ରଭାତ ବାଡିରେ ପିଟିଲା
Uploading. Kimdi? 12695. What 34 is there?
34. Lords, even if all are is there, let the CD come, my lords. I will appraise your lordship in details.
All up-to-date case diary be obtained. Place this matter on Kevin. 1st July. We commencing 1st July. अच्छा से जो dispose of case टा नहीं है उसका पैसा करे
हाँ let both the disposed of records
ना आराटा तो अच्छी अपन order the order is there you have enclosed along with the BLAPL number 126954/2022 it must have been disposed of but the date ta nahi
it has been disposed of as
the date देखिए item 20 ना कहते थे item 20
in 20 I am in custody since 8th of January 2022. Prayer for bail was earlier rejected by your lordship on 10/5/2022 and the second bail application was dismissed for non-prosecution on 1/12/2023.
Sir 1 kg 43 grams.
No, it's not from me.
Let us see that.
The recovery is from a co-accused, my lords. Your lordship may see. Your lordship may see the charge sheet which I have annexed. Brief history at page 12 of Rita Beuria of STF got reliable information that one Safikul Sheikh, alias Khokon, son of late Golam, following due process of law and detected illegally possessed 1 kg 43 grams contraband brown sugar and other incriminating articles from the accused person Safikul Sheikh alias Khokon.
You are not Safikul?
No. Son of late Golam. Inspector Sarita seized the contraband brown sugar from the exclusive and conscious possession of accused Safikul Sheikh alias Khokon in presence of witnesses, as he could not furnish any document or authority in support of such possession of brown sugar with him. During interrogation, accused Safikul Sheikh alias Khokon confessed that he used to carry brown sugar business since more than 15 years. He is addict and used to procure the same from Lalu Sheikh alias Sheikh Lalu alias Lal Muhammad.
You are this.
Son of so and so.
You are Lalu.
Yeah. And Sheikh Kalu, son of Najimuddin, who are noted manufacturer of brown
He is
sugar.
from the West Bengal.
And out of a criminal conspiracy, hatched among himself and others.
And let the CD be called for because
charge sheet ଅଛି call for the CD ହେଲା reopening day ରେ ନେଇଯିବା କିଛି ବଡ କଥା ନାହିଁ but ଏଟା ତ line ଆପଣ ପଢିଲେ during interrogation the accused person said
he is the supplier.
This is
Another bail application.
where I challenged the charge. Your lordship granted stay. Last week I asked for vacation of stay because of the fact that he is
that
in
matter,
custody.
yes.
Yes.
My lord, earlier, my lord, in one case it was rejected. Another it was
rejected. Probably this aspect was not before the court.
Have I not stated it, sir?
No. My lord, another one it was dismissed. In that case, my lord, one CRLM was filed for a restoration. What is the status of that case? Because
what is the status? It has not been restored. Why should you know the status and what is the relevance.
No, but if the earlier application was filed and it was dismissed for prosecution, you may not press that CRLM.
CRLMA, I don't know what has happened because he has taken the brief from this council who has filed it. Council from West Bengal was moving it. So
No,
since it has not been my lords, prosecuted, it remains posted as dismissed for default.
But this we can consider.
My
This
lord,
we can
but my lord, that file may be called for.
We'll
Because in
together we'll
CRLM
call for that file,
it was
whatever, we'll
restored.
regularize it. We'll regularize. That should not stand in the way of a person who is entitled to bail.
Yes, yes.
All right.
But
Anyway, I'll call it in the reopening week. You, in the meantime, you obtain the case that if you want to.
Lord, your lordship is sitting during the vacation time.
Vacation କରିବେ ନାହିଁ। Vacation କରିବେ। ତ ହୁଜୁର ଫାଷ୍ଟ ୱିକ୍ ହବ 18 ତାରିଖରେ ହବ କଣ? Release this matter on କୋଉ number?
18th June.
Week commencing, sorry. It a week commencing ratio. Week commencing 18 June, along with
BLAPL number 6216 of 22.
6216 of 2022. How CRLM matter?
CRLM number is 364 of 22.
And also BLAPL 3228 of 22.
3228 is the here. এটা সেটা ଅଛି। এটা অর্ডারটা তো ଅଛି। ଆମ ପାଖରେ ଅଛି। You may not have enclosed, but it is there with the officers given it. ये बड़ हमको
But I don't have copies of anything.
चश्मा।
When it is checked in the computer also, these numbers don't come out.
I don't know, there must be some difficulty, but the order is there before me. Let us call for that.
Let CRLMC also be listed 4277 of 2020.
CRLMC, I cannot take it up. I can only.
Your lordship did not take it up. Your lordship had called for the records. The case records will be there, available there.
Along with with the CRLMC number.
CRLMC is 4277 of 2020.
4277 of 2022. Yes.
Item 21.
No, your lordship fix a date.
So week commencing 18th ରେ ଆସିବ।
କୋଉଦିନ ଆସିବ ନ ଆସିବ
ଆସିବ ନା ଆସିବନି କି? Week commencing.
Resolution 20B2C.
Yes.
20B2C, this is the second journey of that case.
Earlier withdrawn.
One have supported the prosecution case.
The petitioner is in custody since
28/12/2020.
28/12/2020 in connection with such and such. It is alleged that the petitioner was in possession of contraband brown sugar weighing
330 grams.
330 grams when he was apprehended by police. It is submitted that despite being in custody for more than 4 years, trial is yet to conclude. As a result, several family disputes have arisen which require, as a result of it is submitted that several, in the meantime, several family disputes have arisen which require the personal presence of the petitioner. It is therefore great that the petitioner may at least be released on interim bail for some period. Considering the submissions, London State Council submits that trial is in progress with
8 witnesses.
With 8 out of 21 witnesses being already examined. Considering the submissions and the apparent delay in conclusion of the trial, I am inclined to take a lenient view. By directing the court below to release the petitioner on interim bail for a period of 4 weeks. And such terms and conditions, bail application is accordingly disposed of.
Item 23.
Please, madam. Here the accused petitioner is in custody since 14/6/2023 on an allegation on section 498A and 376(2) of NFIPC due to section POCSO Act. In the meanwhile, the victim has been already examined. I have filed the
3763 is there, notice served.
Notice served.
12/5.
When?
12/5, 12/5.
And State Council submits that notice on the victim has been served on 12/5/2024.
12/5/24.
There is, however, no appearance from the side of the victim for which the bail application is taken up for hearing. Yes.
Section 20B2C of the NDPS Act, madam. Madam, may I audible here?
Yes.
Madam, he is in custody since 7th October 2023, madam. And the contraband article has been seized from the auto vehicle, that is the commercial vehicle. And during interrogation, he disclosed that one Jogesh Hunter, as per direction of the Jogesh Hunter, the present petitioner transported the contraband ganja in his commercial vehicle, madam. And the vehicle checking, madam, police
Sole accused.
Hmm?
Sole accused.
Sole accused.
43 kg, 800 gram.
Kete kg?
43 kg, 800 gram.
And custody is October 2023 and charge sheet submitted on 9th March 2024, madam.
ବର୍ଷେ ହଉ
Madam, only 43 kg madam ଛୁଟି ଅଛି ତ କୋର୍ଟରେ.
ହଁ interim bail ରେ ଯାଆନ୍ତୁ.
Madam.
The petitioner is in custody since କେବେ?
7th October 2023.
7th October.
Madam.
7/10/2023 in connection with such case. It is alleged that the petitioner was in possession of contraband ganja weighing 43 kgs 800 grams when he was detained by police. It is submitted that charge sheet has been submitted.
On 29th March 2024.
But the trial has not commenced as yet. The petitioner is required to attend to certain pressing needs of his family, and therefore he may at least be released on interim bail for some time. Considering the submissions and the materials on record, the bail application is disposed of, directing the court below to release the petitioner on interim bail for a period of 2 months.
High level yours.
Item number 25.
Item number 25, your lordship has granted a judgment today that that is also come. The main allegation by the Rejitri Krishna, we are the conspirator, my lord, 120B allegation. I have last occasion also served the last week. Here the allegation against unknown person, my lord. That while the
You are Rejiti?
Rejitri Ramaraju.
Rejiti Ramaraju.
Brother, son of Jagannath, my lord. That's granted bail where allegation 120B, it's like Jagannath.
Same order.
Yes, madam. 120B is there, my lord.
Custody from 2/7/2023.
His brother Rejiti Krishna. He has given supari to one supari killer.
That supari killer was also killed.
Also killed by Rejiti Krishna along with some
extrajudicial confession also.
on that another case has been lost, my lord. That is pending.
What is the material against this?
That I was along with that my lord, discussing
Along with father and son and another, they only chalked a plan to kill the
only that.
and motive, my lord, previous enmity related to land dispute, my lord.
The petitioner is in custody since
2/7/2023.
2/7/2020?
23.
In connection with such and such case. It is alleged that on 13/5/2023, while the informant Satyaprakash Satpathy was gossiping with his friends including one Gauri Prasad Mishra, on the Vansadhara bridge, comma, an unknown person came there and fired from his gun at point blank range. Stop. As a result, said Gauri Prasad Mishra sustained grievous injuries and subsequently died. Stop. During investigation, it came to light that there was a civil dispute between deceased
Gauri
Gauri Prasad Mishra and Rejiti Jagannatham, for which the latter hatched a conspiracy to kill him. His son, Rejiti Krishna, hired a contract killer, namely V. Rajesh.
alias Raja.
Stop. Thereafter, a plan was hatched, pursuant to which the contract killer killed the deceased in the manner stated above. But insofar as the petitioner is concerned, the only allegation against him is that of being a part of the conspiracy.
Disclosure statement of Rajita Krishna, they all have been implicated.
Confessional statement.
Further, he appears to have been implicated on the confessional statement of co-accused Rajiti Krishna.
Yes.
Stop. In the meantime, the other co-accused persons, namely Dasari Venkatrao, Rajiti Jagannatham, and Akash Kumar Bodappu, have been released on bail as per order passed by this court. Stop. The petitioner stands on same footing. This court therefore finds no reason to treat him differently. The bail application is therefore allowed.
Obliged.
Item number 26.
May I please, your lordship? My lord's petitioner was neither arrested from the spot nor any contraband has been seized from him, my lords. Occurrence took place in June and a petitioner was arrested in September, my lords. Nearly about 3.5 months of the incident, my lords. And only basis of implication is the confession of co-accused Virendra Singh, who was arrested from the spot, my lords. And according to his statement, my lords, petitioner was sitting in a different car, my lords, and he and others were.
What is your name?
My name is, my lords,
Prashant Patel.
Prashant Ketty, my lords.
Ketty.
Virendra Singh implicated me. I implicated some 2-3 persons, my lords. Whom I implicated, they have been released on bail. Those orders are before, lords. Virendra implicated me. I implicated 2-3 persons. Whom I implicated, they were released on bail.
Escorting my lord. That Hyundai car, along with 3-4 persons, they have.
The petitioner is in custody since?
My lords, 25/9/2023.
25/9/2023 in connection with such and so. The prosecution case is that a truck containing contraband ganja weighing 920 kgs was detained by police. Stop. 3 persons, including the driver of the truck, managed to escape. भूल रोची managed हवा कथा इतने कौन बोलो सब line by line हमें देखिए यदि managed to escape while one Virendra Singh was detained. He confessed that one Sankarshan Barik and the present petitioner, along with the driver of the truck and 4 unknown persons, were engaged to load the contraband in the Hyundai car.
No, my lords.
In the truck. They have given load. This present petitioner, along with us, they have given load with the truck and they are escorting the truck in which contraband.
Again, जहाँ लिखा है जी previous order, were to load the contraband ganja in the Hyundai car, which fled away from the spot.
Hyundai car load है, truck load है.
They load the contraband ganja in the vehicle. Stop. The petitioner is also said to have disclosed the name of other persons involved in the, allegedly involved. Stop. The co-accused persons have been released on bail as per order passed by this court, basing on the ratio of Tufan Singh versus State of Tamil Nadu. Stop. The petitioner stands on the same footing. Under such circumstances, bail application is allowed.
Obliged.
Item 27,
Permitted to withdraw.
item 28,
Permitted to withdraw.
item number 29,
ଏଟା withdrawal memo ଅଛି ଆଉ mediation report ଅଛି କଣ withdraw କରିବା ପାଇଁ ବି ଦେଇଛନ୍ତି ଆପଣ withdraw କରିଦବା mediation ର କଣ ହେଲା
ये हेले फादर इन लॉ मदर इन लॉ अंकल
mediation କିଛି ହେଲାନି
मेडिसिन अच्छी पेंडिंग अच्छी आरटा हस्बैंड
so you want to withdraw permitted to withdraw
item number 30,
permitted to withdraw ସରିଲା ସବୁ ବାକି ଗୁଡ଼ା ସବୁ କଣ ଏଇ yes please
Last occasion, my lord, directed to stay of further proceeding, but same is not reflected in the order. So,
I will take further. What about the settlement?
Next date is 6 to 27/6, my lord.
27/6 of no, this is
To take instructions.
to instruction. All right. Have you filed in IA?
Yes, my lord. IA 419, my lord. 416 of 2023.
It is submitted that though the case was directed to be listed on 27th June, yet the matter has been listed today. Stop. Be that as it may, it is submitted that efforts are being made for amicable settlement of the dispute between the parties. Stop. In view of such submission, list this matter on the date fixed. In the meantime, further proceeding in such and such shall remain stayed till the next date.
item number 32,
32, my lord, of the day. Yesterday I filed the hard copy of the so called.
Yes, where is Mr. Patnaik is not there. We'll pass it over, Mr. Das. Pass over. Let him come.
item number 33,
Case of NI Act, my lord. Transfer petition filed on the ground that both the parties are belongs to Dhenkanal and Athagod. Case was filed on Malkanagiri. Last occasion it was referred to the mediation, my lord. Yesterday, my lord, mediation has been failed, my lord. Flag required for a hearing, my lord. Date can be fixed.
Flag X. Excellent. Mediation report. The report of the mediator indicates that the matter has, that the mediation was not successful. Vacation पर सुन लो. Is this matter? Okay,
9th July.
On 9th July.
9th July.
9th July for final disposal. Is there any interim order? Actually, already interim order to continue till then. Now 9th July देली माने इटा mediator successful है ना, otherwise जदि काय हो देखो
नहीं otherwise हमारा संभावना
जाओ
last no.
Whatever is the law, it will take its own course.
item number 35,
Because it's a question of territorial jurisdiction.
And so far they have taken three grounds, my lord. One is that, my lords, that they are saying that, my lords, the.
So you have filed this case in
Malkanagiri, because both are in Dhenkanal and Athagod, and they filed the case in Malkanagiri.
Yes.
केवल सही गोटे रीजन नो से माने दी तीनटा रीजन नहीं चंदी वन इज माय लॉर्ड योर लॉर्ड्स में काइंडली
ना ना मैं सेदिना सुनिबानी
हां
सेदिना सुनिया
से गोटे नहीं चंदी जे कंप्लेनेंट बिलोंग टू दी सो एंड सो तो 144 142 क्लॉज 2 आंसर है कि देयर इज नो बार टू फाइल एज पर द माय लॉर्ड 142 सेक्शन 142 सब क्लॉज 2 माय लॉर्ड आई विल रेज ऑल दिस माय लॉर्ड पॉइंट ऑन दैट डे
ऑलराइट विल पास अ जजमेंट ऑफ
माय लॉर्ड
34.
So 407 is wide power, my lord.
Yeah, Mr. Singh, we'll see. Why are you worried? We'll pass a judgment. Rightly, wrongly, I'll pass a judgment. I have got every right to pass a wrong judgment.
No, your lordship.
I've got every right to pass a judgment, and the judgment can be right and can also be wrong. That is why I'm saying I've got every right to pass a wrong judgment.
Your lordship minute wrong.
ସେମିତି କହିଲା
ସେ ଖୁସି କରି ଦଉଛନ୍ତି ଆଗରୁ ଆଉ।
ସେଟା କାମ ଦବ ବୋଲି କହୁଛନ୍ତି
ଆଜ୍ଞା
ସେଟା କାମ ଦବ ବୋଲି ଭାବୁଛନ୍ତି ନାଇଁ ଆପଣ ଭାବୁଛନ୍ତି
ନା ମୁଁ ମୋଟେ ଭାବେ
ବାସ୍ ବାସ୍ yes
Item 35.
Item 35, my lord.
କୋ interim mediation ଗୋଟେ ଆସିଛି
34.
ହଁ
34 ଟା already ଅଛି.
34 ଟା
Second
oh yes this is 35 କଣ ହେଇଛି ଏଥିରେ
My
Interim
lord, petitioner may provided 2-3 months and he will start again paying the EMI from the the cash security from the month of August.
କଣ ଆପଣ କହୁଛନ୍ତି ମୁଁ କିଛି ବୁଝିପାରୁନି
My lord, the petitioner is already paying the cash security.
what has happened what was the order please tell me that
My lord, in the previous order, the petitioner was directed to pay the cash security in 24 equal installments.
7 ଲକ୍ଷ ଟଙ୍କା
Yes, my lord, the petitioners have
instead of condition to furnish cash security of 7 lakh he shall furnish cash security of rupees 1 lakh ହେଲା he shall pay further amount of rupees 2 lakhs in 12 equal installments ତାପରେ property surety of 5 lakhs you have completed then the prayer modify ହେଲା instead of 12 equal monthly installments 24 equal कर दिया गला तापर कौन बर्तन 48 कर दिया जीव ना कौन
no, my lord. My lord may provide the interim relief for 3 months. The petitioner will again start paying the cash security from the month of August.
7 lakhs I brought it down to 1 lakh I had originally granted you 12 equal installments to pay it by 12 equal installments that I changed it to 24 now again you want to no
My lord will pay the cash security.
no nothing this will become a mockery of justice no
Okay.
who is your senior
My lord, Mr. Siddharthas.
call him because I'm going to reject it
My lord, this is my personal briefs.
very good but I will not allow it
Oh, bless me.
why do you want it to be allowed why
My lord, his mother is sick and he has financial problems going on right now. So he will pay the.
your name is Shivani Samarpita your name
Yes, my lord.
why did you say Siddhartha Das
My lord, you asked me who is my senior.
Achha, so this is not his brief
No, my lord.
okay all right no problem therefore further modification of order dated 17/11/2022 passed by this court has been made to the effect of seeking 3 months further time to furnish the cash security amount of rupees 2 lakhs. Stop. This court has already granted sufficient liberty to the petitioner. Nevertheless, considering the fact that how much you have paid already?
My lord, when the cash security was rupees 17,000, we have already paid like 4-5 installments, and then for a period of 1 year, since the order passed in 2023, we are regularly paying the cash security. We just need 3 months of gap so that we can again continue to pay the cash security from the month of August.
It is submitted that the petitioner is ready and willing to comply with the order, but needs a gap in order to arrange the requisite amount. So considering the submissions and taking note of the submission, taking note of the fact that the petitioner has been paying the monthly installments, I am inclined to take a lenient view. 1 month break is allowed to the petitioner from paying the monthly installments. 1 month. Yeah.
Bless me.
Yes.
Item 36.
Yes, item 36. Correction be made accordingly.
Item 37.
May I please your lordship? Lordship, this
For
is the
interim bail.
My lord, the wife of the petitioner, Josna Rani Sahu, is suffering.
But Mr. Paddy, you are there?
Yes,
Copy of the IA has not been.
You are for the informant.
the informant, your lordship, gone short case.
9 May 2024 ରେ କପି ଦେଇଛି।
ଧରିଛନ୍ତି ତାର ପ୍ରମାଣ ଧରିଛନ୍ତି
ଆଉ ଗୋଟେ ଦେଇଛି।
ହେଲା ଇଏରେ କଣ ହେଇଛି ଦେଖିବା କଣ ହେଇଛି ମୁଁ ଦେଖେ ଯଦି ଦରକାର ହବ yes Ms. Dasma Patra, what is this?
Madam, the wife of the petitioner, Josna Rani Sahu, is suffering in chest.
କେତେ IN number ଟା କେତେ କୁହନ୍ତୁ
IN number, my lord, 938.
938 938 ନା
938 ନା
498
43, sorry,
498
498. 498.
chest and cardiac problem with gynaec trouble DHH ढेंकानाल SCB cardiology department कौन सब लिखा है
Except the petitioner, there is no other male person in the family.
what is the
My lord.
allegation?
Doctor advised and also gave the phone number. Allegation, the petitioner wife. 302 offense under section 302.
Yatra chaltuva bele lordship gone through the deposition and lordship was not inclined. So there was not a motive into gunshot.
Gunshot.
Yes.
My lord, I have
Eyewitnesses are
already.
also there. Eyewitnesses are also there.
Yes.
She's asking for interim bail.
I already filed the deposition copy and also lordship ଜଣେ ଖାଲି କହିଛି 2 ଜଣ କହିଛନ୍ତି ସେଟା ପୁଣି ରିକଲ୍ ବି ତାଙ୍କର ସେ କରୁଛନ୍ତି
ସେଟା ତ କାଇଁ କଣ ଜଣେ କହିଲେ ବି ହେଲା
ନାଇଁ ସେ ବି ନଥିଲେ ଘଟଣାସ୍ଥଳରେ ଆଟ୍ ଦ ପ୍ରେଜେଣ୍ଟ ଇନଷ୍ଟାନ୍ସ
ସେ ତ ନଥିଲେ ସେଟା କୋର୍ଟ ବିଚାର କରିବେ ତଳ କୋର୍ଟ ବିଚାର କରିବେ ଆମେ କାଇଁ
20 ରୁ ରହିଲାଣି ସେ ବର୍ତ୍ତମାନ ତ ୱାଇଫ ର ଦେହ ସିରିୟସ୍ ଅଛି
एकदम सीरियस
ମାଇ ଲର୍ଡ
କିଛି ନାହିଁ ଆଜ୍ଞା ସିରିୟସ୍
Granted bail.
ସିରିୟସ୍ ମାନେ
ମାଇ ଲର୍ଡ ସେ cardiac problem and also
କଣ ପ୍ରୋବ୍ଲେମ ଲେଖି ପକେଇଛନ୍ତି ଆପଣ କାର୍ଡିଆକ ପଟେ କେତେ କଥା ଲେଖିଲେଣି ସେ ବଞ୍ଚିଛି କେମିତି ସେ ଲୋକ
ECG ଅଛି ଏଠି ବି ଅଛି
ଇସିଜି ଆପଣ ସେଟା ବୁଝି ପାରୁଛନ୍ତି ସେଟା
ମୁଁ ଜାଣିନି କିଛି
ଆଉ ତାହେଲେ ମତେ କେମିତି ଭାବୁଛନ୍ତି ମୁଁ ବୁଝିବି
ମାନେ ଏଠି ଅଛି
ଆଜ୍ଞା ଆଜ୍ଞା ମୁଁ କଣ ଡାକ୍ତର
ନାଇଁ
ତାହେଲେ ଆପଣ ଭାବୁଛନ୍ତି ମୁଁ ଡାକ୍ତର କି କଣ
ନାଇଁ
ଆଉ ସେ କୋର୍ଟ ଇଜ ଏକ୍ସପର୍ଟ ଅଫ ଏକ୍ସପର୍ଟସ
ମାଇ ଲର୍ଡ
ଜାଣିଛନ୍ତି ନା
ମାଇ ଲର୍ଡ
କୋର୍ଟ ଇଜ ଆନ୍ ଏକ୍ସପର୍ଟ ଅଫ ଏକ୍ସପର୍ଟସ Yes. 4 weeks.
Condition था every week appear करियो थाना रे
हाँ सब ये बड़ी से मिस्टर पाड़ी
It's not your lordship. एभलिया ग्राउंड रे आगुरु my lord has been pleased to grant interim bail for 4 weeks on 15/5/23 again on 8/6/23 and on a similar ground 19/2/23 रे गोटा reject हेतिला I leave it to my lord. ಇದು 6 क्रिमिनल एक्सीडेंट अछि और while in custody भी गोटे केस ता थिला
of the petitioner's wife. It is submitted that she has been suffering from a host of ailments such as cardiac problems, gynec problems, etc. Certain medical documents issued by that the petitioner was earlier granted interim bail on similar ground. Sri S.K. Paddy, learned counsel appearing for the informant, opposes the prayer for bail by submitting that the petitioner has several criminal antecedents and if released, he may terrorize the prosecution witnesses. केते जण witness examine हबो को छंती
45 ରୁ 22
This court finds
22
that 21 witnesses have already been examined out of 44 charge sheeted witnesses.
45, sorry.
There are medical 45. There are medical papers to support the submission regarding illness of the petitioner's wife. Under such circumstances, I am inclined to take a lenient view. Let the petitioner be released on interim bail for a period of 4 weeks. On such terms and conditions, On the condition, one, he shall appear before the IAC of Kothana,
Dhenkanal Sadar.
Dhenkanal Sadar Police Station on every Sunday at 10 a.m. and such fact shall be certified. Hala. Tapare. Each day appearance in the court without seeking representation. Next, list the bail application for hearing on. I would he shall not terrorize or otherwise influence the prosecution witnesses is in any manner. List the bail application for hearing on.
In the week commencing 1st July.
In the week commencing 1st July.
Item 38.
Earlier, is allowed because they granted 6 weeks, there is a extension of interim order. Today is the date of surrender matter. Only I pray mother is seriously ill and he's in bed.
How many times has the interim bail been extended?
Only once. 6 weeks.
28 दिन रे
6 weeks दिया था but out 3-4 weeks दे
Considering the submissions, considering the submissions, I will this is an application for considering the submissions, the interim bail granted by order dated 28/3/2024 is further extended by a period of 4 weeks.
Copy in course of the day.
In course of the day, Please this bail application in the week commencing 1st July. Yes.
Item number 39.
Yes. Like in this case, my lord directed to release its condition, my lord. The condition is that he should submit a property security of 20 lakh rupees, my lord. The petition is a BPL category, my lord. Having no property, etc., after that in custody from long. I have carrying the BPL card, etc., my lord, for my show it. So he has requested his maternal aunt, Mausik request this property he has, if my permits. In place of he, the name of the maternal aunt can be replaced. Unless
Why should we object? We'll say that he may be allowed to furnish property surety amounting to rupees 20 lakhs.
Not my lord, he has not 20 lakhs. He has just less than 5 lakh, my lord. He has no property. Even if I have attached that copy, that I've attached that.
What you have attached?
That property details. Only he has तार केवल माउसी जणी अछि जार के प्रॉपर्टी छ किछि नै माला
इसेतमे ये चोरा धंदा करथला अपन ड्रीम 11 खेली के कोटी कोटी केतना से नैछि 34 लाख 37500 टका से नैछि
मतलब इन पर्सनेटिंग हिमसेल्फ एज ए गर्ल से लोक पैसा एक्चुअली फैक्ट होछ मतलब ड्रीम 11 खेलुथले
तबे से निजु को झियो बोली कहि कि फेसबुक रे पैसा नैछि
समझ से कहि नै से चैट करछि ता सहित माने ये कहउछन एलिगेशन एटा एक्चुअल
एलिगेशन तो सब एलिगेशन
एक्चुअली से ड्रीम 11 खेलुथले जोथरे के लॉस हला फैक्ट होछ सेटा आई हैव कन्फर्म लास्ट टाइम आला so this is all about what well I am giving this BPL card of his mother also.
Well, property surety, how much you can give? 5 lakhs.
Mention less than 5 lakh. He has only
5 lakhs. 5 lakhs.
Only one property.
What will be the value of that property?
That I am not ascertain, but we have submitted before the Malad. Yes, ma'am.
Who jagare?
It is Malad. Kuda Khandita, Silicon Jam.
Padara ek. Padara means Mr. Das. What is Padara? Kisama? No, Padya Jamin.
Exactly. Now remember.
It's what property. 24 days.
There's another Dogoro, then Padara.
Yeah,
what is Padara? Padara na Padya? I don't know. It is prayer for modification is made on the ground that the petitioner, because of his poor financial condition, is unable to furnish because of absence of property of the value. Because of absence of any valuable property, he is unable to comply with the condition imposed by this court to furnish property surety of rupees 20 lakhs. A copy of the ROR standing in the name of his maternal aunt has been enclosed to the IA. It is submitted except for the above property, comma, the petitioner has neither any property nor any interest in any other property. He therefore requests for waiving of the said condition. This court finds that despite the order granting him bail, the petitioner has not been released. As such, no, it has not been released. So taking a lenient view in the matter, the order dated 8/5/2024 is modified only to the extent of imposing the condition of furnishing property surety worth kete dei paribe
20 lakh dei paribe
हाँ.
less than 5 lakh eita jetti khava again de dobo that mention we have mentioned that
property surety
mention in the name of Bimala Maharana is maternal aunt.
Property surety to the extent of the property belonging to one Bimala Maharana. No, yeah, how do we know that he is your maternal aunt?
He is maternal. This fact matter.
No.
This ଆସିଥିଲା Bimala Maharana
ଦେଖନ୍ତୁ କଣ ଲେଖିଲେ of rupees 3 lakhs है ना
property surety 3 lakhs
ଯାହା ଦେବେ ଯାହା କୋର୍ଟ accept କରିବି ଦେଖିକି
ମାନେ in place of he we have mentioned
no you will furnish 3 lakhs you will arrange
in relatives
it shall be open to the petitioner to furnish the property surety relating to properties standing in the name of any of his relatives.
Yes. Great matter.
Item 40.
May please your lordship, I am VC my lord. Your lordship pass an order, first or second or I prefer only parity, my lord. Because co-accused person already listed.
Modified to the extent of adding parity.
Item 41.
So I have filed the appeal for modification, lordship. Last occasion, lordship directed to the instruction, lordship, regarding the payment, your lordship.
What payment?
My lord, the brother and dispute between two brothers, your lordship, they have taken the money which you have returned, your lordship.
No, on the ground that in the meantime the amount outstanding has been paid by the petitioner.
He has already refunded that saving certificate bond.
So what needs to be modified? And State Council submits on instructions that in the meantime the entire outstanding amount
Saving certificate bond of that amount. The bond he has repaid.
Entire outstanding amount has been repaid by the petitioner in the form of
saving certificate bond.
Stop. In such view of the matter, the condition imposed by this court for deposit of rupees 50,000 towards cash security is waived. Yes.
Highly grateful, Lord. Oh, please.
Item 42.
My lord, on behalf of Rakesh Malik, he has requested me to submit his details, madam. Extension of time 3 weeks is open.
For time to?
Extension of 3 weeks time. For
କେତେ ଥର ଆଗରୁ ହେଇଛି?
Perhaps this is second time.
Pramod Rai. Well, at 3 weeks for the time.
Grateful, madam.
Item 43.
Pardon, the lordship, time may be extended, your lordship.
Qualifier से 3 को ସେଥିରେ ଓ ଆର କେସ୍ ରେ या ପୂର୍ବଟା ଯୋଟା ବେରାଉନରେ ସେଥିରେ 2 weeks time extra କରିଦେବେ 2 weeks for
grateful.
Yes.
43 my lord, is the phrase dated my lord. The last the yellow should have to correct the cost title, my lord. The order dated in order sheet paragraph 4, the order dated loan and SDGM not corrected due to the loan and code bill not accepted the order. The paragraph 4 of the order dated 2/1/2024, my lord.
SDGM ନୟାଗଡ଼ ତ ଲେଖା ହେଇଛି
ସେ ଗୋଟେ କରେକ୍ଟ ହବ JMFC
JMFC ହବ ଖାଲି
ଆଜ୍ଞା
ସେତିକି ଖାଲି ହବ ତ
ଆଜ୍ଞା
therefore modification is allowed instead of SDGM Noyagod let it be mentioned JMFC Noyagod
para 4 of the order my lord
in paragraph 4 of the अपन देखिए कर रहे
another period 2 weeks
2 weeks for the time
Item 44.
JMFC Ronapur my lord JMFC Ronapur JMFC Ronapur ଏଇଟା sorry ମାନେ sorry
your name is Mr. Jaydev Behra तो
ଆଜ୍ଞା ଆଜ୍ଞା
ସେଥିରେ କିଛି ଭୁଲ ନାହିଁ ତ
ଠିକ
ରଣପୁର
JMFC Ronapur
Item 44.
ଆପଣ ବୋଧେ ଭ୍ୟାକେସନ ରେ ପଳେଇଲେନି yes
Your Lordship, I'm appearing on behalf of Mr. J.K. Kuntia
हाँ हाँ
for petitioner number 2. I pray for 3 weeks time to surrender.
petitioner number 2 petitioner number 1 has already surrendered
Petitioner number
and released on bail so you want further time for petitioner number 2 all right 2 weeks for the time you allowed to petitioner number 2 to surrender yes
Item 45.
none appears after vacation
Item number 46.
May I please, Your Lordship? Your Lordship, I'm seeking a modification of the order dated 23/4/2024, wherein a direction was given to the IO to accept the document produced by the petitioner. However, no time was stipulated. That is why it was.
yeah yes Lordship directed to take instruction my lord kindly see that I petition number 1282 man para 1 madam that the Bodosai PS case number 42 of 19 we have taken instruction that no such case is pending against the present petitioner and he is not related to that case madam. Actually my lord he has filed that PS case number he has given wrong that is actually Chandaka PS but he has given we have taken instruction from that case
Your Lordship, in the order, the correct case number was mentioned in the.
ଆପଣ ଆଇଏ ଦେଲେ ଆଇଏ ଯାହା ଲିଖିଲେ ସେ ତାରି ଉପରେ ନେବେ ନା ଏ ଦେଖିବେନି ଏଗୁଡା
Inadvertently, Your
ଇନଆଡଭର୍ଟେଣ୍ଟଲି ମାନେ କଣ ମତେ ଟିକେ ବୁଝେଇ ଲାଗେ ନା ମୁଁ ଜାଣିନି ବୋଲି ଜାଣିବି ସେ ୱାର୍ଡର ମାନେଟା କଣ ସମସ୍ତେ କହୁଛନ୍ତି ମୁଁ ଏପର୍ଯ୍ୟନ୍ତ ଶୁଣିନି ସମସ୍ତେ କହୁଛନ୍ତି କଣ ତାର ମାନେ କଣ
Lordship, by
ଆପଣ ୟୁଆର ଦେଖନ୍ତୁ କେତେ ବଡ ମିଷ୍ଟେକ୍ ଏଟା ୟୁଆର କେସ୍ ରିଲେଟ୍ସ ଟୁ ଚନ୍ଦକା ପିଏସ୍ ୟୁ ଆର ରାଇଟିଂ ଆବାଉଟ୍ ବଡସାହି ପୋଲିସ ଷ୍ଟେସନ ବଡସାହି ଇଜ ଇନ୍ ମୟୂରଭଞ୍ଜ ନା ବାଲେଶ୍ୱର ବଡସାହି ଇଜ ମୟୂରଭଞ୍ଜ ଚନ୍ଦକା ଇଜ ଇନ୍ ଖୋର୍ଦ୍ଧା
Lordship, the order that I was referring to.
No, that's all right. That is all right. I'm willing to do that. But how can now this has to be amended.
that I have taken instruction from board of
The IA has to be amended and he has to take instruction from the correct police station.
ତାକୁ ପୁଣି ବହୁତ କଥା କହିଲି ମୁଁ କହିଲି you will not avoid by the ଦୁନିଆ କଥା ଶୁଣିଛି ତାକୁ
and ladies she submit that document I will talk the
Yes.
Your Lordship,
No, she only wants that some time.
he is not accepting that his allegation is her allegation is that he is not accepting that document
until a time period is stipulated, he says that
You do one thing. This IA, it correction. Going to talk this. So you do one thing. You correct it. Make the necessary corrections in the court. I will pass that order.
Right.
I will simply say that within such and such time he will consider it. Right. That's all. The learned counsel for the petitioner is permitted to correct the typographical error in the interlocutory application in court. You will quote in court, you will do it. So, considering the submissions. No, it is submitted that considering the submissions order dated 23/4/2024 is modified only to the extent of adding the following sentence at the end of paragraph 7. Stop. The IO shall take a decision on the document so produced by the petitioner within 2 weeks, right? Within 2 weeks.
much obliged. Your Lordship, until then, no coercive action may be taken.
What's Hilagi?
Your Lordship, this is a
Till such time, no coercive action. Till such time, no coercive action shall be taken against the petitioner.
much obliged.
when your lordship has already stated that
The document is produced before the IO within 2 weeks.
Within 2 weeks, she will produce it. But decision to be taken by the IO within 2 weeks. That is what I'm saying.
And decision he has to either charge sheet or whatever.
Yeah, 4 weeks.
He has to produce the document, so it will be times to place.
Accept Kurunati.
No, that will also may reflect that he is to accept the document. Because it will be that he will file charge sheet within specific period of 2 weeks.
Therefore, modification is allowed by adding the following sentence. Sir, এই প্যারাগ্রাফটা একটু চেঞ্জ করে দেখাবো মানে এই যে সেন্টেন্সটা if such a document is produced হ্যাঁ the last sentence of paragraph 7 be substituted as follows. If such document is produced before the IO within 2 weeks from today, comma, the same shall be accepted and considered on its own merit. That's all.
Much obliged.
Item 47.
May I please, Your Lordship?
Till such time, no course of action be taken.
Your Lordship, may I please?
Yes.
Your Lordship, I am appearing for the modification for an order dated 23rd February 2024.
Yes.
On time to surrender before the Honorable Court. Your Lordship.
Only 2 weeks further time is allowed.
Most obliged.
48 extension of time of surrender anticipated 2 weeks further time.
The first time is
First time.
2 weeks further time.
First of all, item note 7.
7 to pair of. So, Tripati, yours matter? No. 7 count. Anticipated bill. Fresh. Yes, yes. Mr. Tripati, what is it? Who Nanti?
Business dispute transaction between the parties, madam.
Oh.
He has taken the highway, my lord.
307 कौन अच्छी जे?
307 खाली कहले जे
Kitchen, Lordship, pass the bus for because
Oh, the other side was.
other side is not there.
yes, that's why Lordship.
My instruction, my lord. ए matter रे final report ହେଇଛି ତେଣୁ କିନ୍ତୁ କିଛି documents
7-3 ରୁ ଆସିଲାଣି.
Should I keep it to after vacation, granting him no course of action?
ଆଜ୍ଞା ଏ ଅଛି interim protection ଅଛି.
अच्छी तो. The petitioner is, the learned counsel for the petitioner is present. None appears for the informant. Let this matter in the week commencing 18th June. Interim order to continue till then. Yes, I would have.
So that note 32.
On behalf of Mr. Patna, already complied, my lord.
Already completed then? Good. You have filed the compliance affidavit?
Yes. Only defect is that communication was deleted.
No, no, जहाँ है वो, हमें कहीं से थ्रू पुष्पा. Compliance affidavit has been filed by learned AG. এটা ଅଛି ଆମର compliance affidavit କାଲି से file करते हैं. The learned counsel for the petitioner also submits that the order of this court has been complied with. In view of such developments, nothing further remains to be decided in the contempt application, which is therefore dropped. So, end of the matter.
Our action to the Lordship.
Same to the bar. May everybody have a good time, relaxing time. Thank you.